We're talking about the struggle against Section 377 of the Indian Penal Code, which is a provision which criminalizes what it calls carnal intercourse against the order of nature, which in effect criminalizes same-sex relationships and alternate gender expressions in the country. And the challenge to this was really filed in 2001 by a group called Naz Foundation, and Lawyers Collective filed it on their behalf. And they challenged the constitutionality of the provision on the basis that it violates the right to equality, the right to privacy, the right and the right to, and the right to dignity. And what you're referring to is in 2009, in some ways unprecedented or far ahead of its time judgment, the Delhi High Court uh, ruled that Section 377 should be read down as it violates the right to equality, the right to privacy, and the right to dignity of the LGBT community. The Lawyers Collective ensured that there was a wide level of community consultation around every aspect, every process as far as the judgment was concerned. Every single step, be it the dismissal of the petition, be it the filing of the review petition, be it the intervention filed by Voices Against 377, there's a consultation which is organized with community members, which is hosted by a lawyers collective, in which community activists express their opinion about what they thought the lawyers collective should do in this particular context. I mean, the point I'm really trying to make is that from the very beginning, there's a level of the involvement of the community as far as the petition was concerned. That the petition was not a petition which was filed by person A or person B, but the petition which actually represented a wider collective of people uh, around the country. Uh, what is unique about the Naz Foundation case is at the forefront was an organization or organizations which strove to represent larger collectives of people. Naz Foundation, of course, represented the community of men having sex with men, and the difficulty of HIV/AIDS, how HIV/AIDS intervention was impeded by the by the law. If you take the intervention filed by Voices Against 377, Voices Against 377 was a coalition of child rights, women's rights, and LGBT groups. Again, what is unique about that is you're communicating a perspective or a framework that this issue matters to a grouping which is wider than the LGBT community alone. And that there's a way in which this is an issue of deeper issue of democracy and deeper issue of fundamental rights, which is at stake as far as this particular uh, as as far as the struggle against this particular law is concerned. When we filed the case itself, the thinking, I mean, again, why do people file cases? You file cases to win victories. That's why you file cases. I mean, in a simple kind of a way. But when we filed the case, or when the case was filed, I don't think it was in the back of any of our minds that we're going to win this, that the law will go. We felt that this is a chance for you to mobilize a wider community around the issue of the rights of the LGBT community. That was what we felt. That was what we thought. And again, for those who are skeptics of the law, the point to be noted is the law is a mobilizing capability, which a meeting does not. You can call a meeting in Delhi or Bombay or wherever else it might be, and maybe people in Delhi or Bombay or a small circle will know about that particular meeting. Once you file a case against law, the media reports upon it, and the media reports carry to all corners of the country. So people who you don't know about this particular case. So in a sense, the popular mobilizing potential of a case is actually incredible, and that was the main thing as far as we were concerned. We said this campaign, this law, this case is a way to build a campaign at the ground level and to increase awareness and around the rights of LGBT people. That's the way we saw it, And we said there's a long-term struggle. It might take God knows generations, but this has to be done. And so we were not when the first time I was in court when Justice Shah, Justice Mulidhar began the hearing, we were the good judges, but we didn't. I mean, we didn't have any great expectations in that sense. But then during the hearing, Justice Mr. Anand Grover began his submissions with the Wolfenden Committee report. The Wolfenden Committee report is the report which was in the UK, which basically, on the basis of which the decriminalization of same-sex relationships happened. And the Wolfenden Committee report made a very simple point. They said there's, in brief and in crude terms, an area of personal immorality which is not the law's business. Basically, if you put it in another way, what happens in your bedroom is your business, right? And we began, Mr. Grover began with that report, and the judges seemed like it's not good enough. They're like, yes, yes, all that is fine, but you know what? Don't you think there's something more integral to sexual orientation, gender identity, or sexual orientation in this particular case? Uh, it might be the question of what happens in bedroom, may not bedroom. That's not really the point. But the point is it not a part of who people are? So they were saying that, in effect, they were telling us that, this is a 1957 report. The world has changed. You can't be saying that what happens in your bedroom is your business. You need to move way beyond that. And it came to Shandivan's arguments. That point came across very, very, very powerfully, because Justice Shah again reproduced an argument which came from the Government Council. Mr. Devan, Article 21, there is the basis for limiting your right under the clause of morality. What is your response to that? Shandavan's response was, he says, Your Lordship, there is a basis for restricting rights under 21. We know that. But when it comes to issues such as dignity, which is so integral to the human person, there's no law on earth which can be allowed to restrict the right to human dignity. And the judges seem to get that. You could see Justice Shah remaining silent, saying that, concurring, seeming to concur with the opinion which was expressed. So you got a sense that this was an extraordinary bench, and they were getting it. We spoke a little bit about the entire question of stereotypes. Again, that was a very integral part of the judgment. When the judges read that they know that the guarantee against non-discrimination in Article 15 included the guarantee to be a freedom from stereotypes which are just confine and limit LGBT people's ways of behavior. For this, they drew upon a Supreme Court judgment, which is Anuj Garg, which lays down that stereotypes were offensive as far as Indian law is concerned. Offensive not just in an abstract philosophical sense, but offensive in terms of the way they impair your right to dignity or impair your right to equality. So the idea that LGBT people are perceived as no more than sex acts that they perform impairs the sense of equality, impairs your right to non-discrimination, impairs your sense of dignity. So that's one line which is very, very important. The other important framework which Justice Shah got in is the entire issue of dignity. Again, there's a very important dimension to the LGBT rights question, because perhaps the integral question which LGBT people face in a everyday sense is a sense of being made to feel less than human by being subject to a form of humiliation by either civil society actors or by the state. The state, of course, in this case, does it through 377 when it tells you that the certain kinds of sexual conduct which you may engage in are really fall outside the frame of what it is to be human. They can only be considered animal-like. So the state does it through Section 377, and society does it in terms of the way they deal with LGBT people. So the point which the judgment makes is dignity is integral to the constitutional order, and its dignity, which is violated by Section 377 of the Indian Penal Code. How is dignity violated? The argument is this: dignity, end of the day, is really about your right to make decisions about your intimate life. Who you choose to be with, who you choose to marry, who you choose to love, is a part of of a realm of the human person, which is inviolable. It's an zone into which neither society nor state should be allowed to intervene. And in this case, because the state intervenes, it violates your dignity in a very, very fundamental sense. And I guess you think about it. I mean, if somebody says uh, you can't eat this kind of food, if somebody says you can't wear these kind of clothes, if somebody says you can't love this kind of a person, all of this impairs, confines, constrains your human personality, and really is an attack on your right to human dignity. So that's the dimension which judges got, which I thought was very important. Again, the importance of this, I'll put one last line on this. Um, Go back to our original starting point. When we say that that the when we say that the your right to who you sleep with is your business, that's one way of framing it. But then the other way of saying it is who you choose to have an intimate relationship with is a part of your right to dignity. That's the other way of framing it. And so the justice Shah is on the second way of framing it. He's saying that this is a part of the human personality. Everybody has relationships with people they love, and if that is the case, and the law which says that you can't have relationship with someone you may love, then that's a fundamental infringement of your right to dignity. So again, you're linking up the question of sex and dignity, which is a very interesting kind of a formulation. It's never been done in the Indian context quite in the same way till then, where you have this way of thinking of dignity and sexuality as interrelated phenomena. That's one dimension I want to speak about. The second dimension, I'll very quickly mention, is the issue of privacy. Again, when you say privacy, privacy is often seen as a zonal right. What you do in your bedroom is your business. Getting back to the same concept. But Justice Shah's viewpoint is privacy as a zonal component, true. It also has a relational component and a decisional component. When privacy is also about your right to make decisions about your intimate life. And that he derives from the line of US Supreme Court decisions on abortion, where you say a woman's right to abortion is part of the right to privacy. Right? And so he derives it from that line of thinking. And he also derives it from, interestingly, from the US Supreme Court Loving versus Virginia, which is the case where Virginia had laws which prohibited uh, a black man and a white woman from getting married to each other, or a black woman and a white man, either ways, from getting married to each other. What we call anti-miscegenation statutes. So the Supreme Court struck down the anti-miscegenation statute on the ground of violates your right to privacy. End of the day, Mr. Loving, the name of the person who's loving, Mr. Loving had a choice to marry whoever he chose to marry. How can the state come in and say you can't marry a black woman? You know, it's ridiculous. Was the U.S. Supreme Court's opinion. In a similar way, if the state comes in and says you can't love person A, person B, that's a violation of your right to privacy and dignity. So privacy and dignity are really interrelated concepts. That's the viewpoint which the judges put forward. And the final point I'll make, which the judgment put forward, is that is to, of course, locate the entire discussion within the framework of the Constitution. And here again, the great contribution which the justices put forward is to link it to both Nehru and Ambedkar. We got in Dr. Ambedkar through the viewpoint in the Constitutional Assembly where he says that constitutional morality is not a natural sentiment. Our people have yet to learn it. We have to cultivate it. And then he goes on to say democracy in India is a top dressing on a soil which is essentially undemocratic. Again, what is Dr. Ambedkar trying to say here? What he's trying to say, the point he's trying to make is simply this, saying that, you know, why do we have a constitution in place? Why do we have a notion of constitutional democracy in place, not a majoritarian democracy? It's because we know that in our country, the majority could be fundamentally undemocratic. We know that the majority can oppress or deprive a minority of rights. If that is what we know of our country and of our society, then the courts have a unique and very important obligation. The obligation of the courts is to protect the minority from the deprivation of rights based on based on the prejudices of the majority. And that's where the notion of constitutional morality comes in. And the protector of constitutional morality, end of the day, are the constitutional courts. It might be useful to refer to the report which has been brought out by the Alternative Law Forum, authored by two of very very well-known trans activists in the Bangalore context, which is Rumi Harish and Sunil Mohan. And it's an extraordinary report. And I think perhaps we can, their viewpoint is when it comes to a crisis or a catastrophe, which is like COVID-19, the people have good impulses, say we want to do something about it. And the good impulses often manifest as a form of charity, saying, here, take some food, here, take something, take, and giving people stuff. The entire point is the act of giving should be within the framework of dignity. You don't throw things at people. You don't treat people less than human. People are not beggars coming before you, as it were. People are in a difficult situation because of the circumstances created by the state. When and simple point, if you're saying a large majority of the trans community in Bangalore is engaged in either sex work or monkey or begging. If that's what they're engaged in, you impose a lockdown, how are they going to take the livelihoods forward? So you've deprived them. The state has deprived them of a certain form of livelihood. In which case, what are you going to do to ensure that they have the right to livelihood in the interim period? And I think the report answers that question, keeping in mind the idea that it can't be a form of contemptuous charity. It has a form of respectable, where you treat people with respect. So dignity, end of the day, is founded on the fundamental point that you see the person before you as a human being entitled to the respect which all human beings have. Once you have that framework in mind, then dignity gets into operation.